Good afternoon, everyone. On behalf of organizing committee, I warmly welcome you all to the sixth TGA Virtual Moot Court Competition 2025, conducted by Thomas George and Associates. I am Vaishnavi Gupta, and I will be moderating the all the participate cameras on through proceedings and kindly ensure that any technical issue should not affect the works. For today's round, we are honored to have Advocate Venkat Reddy, Dhonti Reddy, and Advocate Ravi Chandra Sir as our esteemed judges to educate this round. And we extend our warm welcome to you all Thank you so much, sir. With the permission of bench, I will proceed with the introduction of our honorable judges.
Yes, you can proceed.
Advocate L.
Yeah,
Ravi
go
Chand is
ahead.
a rank holding.
He spoke on behalf of both of us.
Thank you, sir.
Advocate L. Ravichand is a rank-holding economic graduate from Usmania University, Hyderabad. He also possesses a law degree from Chennai. He has been practicing law for over 4 decades now. He is also a part-time journalist. Apart from law, he has a passion for debating movies, classical music, and quizzing. Moving forward, we have Sir Advocate Dr. Venkat Reddy Dhonti Reddy. He is a senior advocate. He holds various academic qualifications, including an MA, LLM, PGDHRD, PGDARD, PGDCL, and IPR, and PhD in law. Before joining the advocate profession, he has worked with Indian Force in firefighter aircraft for 18 years from 1985 to 2003. Dr. Venkat Reddy has
मेरा
enrolled at the bar
टीवी के नीचे
to
एक चार्ट
practice as
है
an advocate
उनसे
on
एक्सट्रीम साइड में
3rd
बॉक्स में
September 2003, and he is specialized in various areas of law, including IPR, constitutional matter, and mining related matters. Venkat Reddy is also the founder of RVR Associates law firm, Vice President of AIPPI India Group, a member of INTA, and a life member of FTA, PCCI, and NIHRD. He has also been a president of ALERT. Along with a huge achievement, Dr. Venkat Reddy has been a guest faculty at Hyderabad Central University, Law University College, and Nalsad PG Law College, OU, ICFAI Law College, JNTU,
when you
and
say no
Symbiosis Law College. He has also been a speaker and moderator at the Global IPR Conference, speaker and moderator at the World Intellectual Performance and Gorilla IPR Conference. Now, with the permission of benches, I will proceed with the rules of the session. So, shall I proceed with the rules?
Yes, you can go ahead.
Why are
In
you
case
asking
any
for
participant
permission?
Okay.
And I told you
In
already,
case any
Mr. Reddy is speaking on behalf of both of us.
Okay, sir.
Thank you, sir.
In case of any participant faces internet connectivity issue resulting in interruption, a maximum 5-minute extension may be granted. Each speaker will be allotted 15 minutes. We respectfully ask the bench to kindly note not to grant any extension due to the
June
paucity
5
of time.
of June
The
2020
structure of proceeding will be as follows. Counsel 1 and Counsel 2 of the appellant will present their cases first. This will be followed by Counsel 1 and Counsel 2 of respondent. All the participants are reminded to maintain a good and stable internet connection and ensure that your cameras remain on throughout the proceeding. The judgment may be shared screen only with the prior permission of the judges. Before we begin the round, please note that the time will be strictly monitored to ensure the smooth conduct of the session. I will inform both sides through the chat box when there are 3 minutes left, 1 minute left, and at last when the time is over. With the kind permission of the benches, the court is now in session. I wish all the best to the teams.
Good morning, sir. Am I perfectly audible and visible?
Yes, you're audible.
Sure.
You're
Thank you, sir.
visible too.
The council seeks permission to address the bench as your lordships.
Yeah, please.
Much obliged. Your lordships, this is Council 1 arguing on behalf of the appellant. The council would be taking 15 minutes of the court's time and deal with issue 1 and 2. And my co-counsel would be dealing with issue 3 and 4 and would be taking 15 minutes respectively. The council seeks permission to explain the facts of the case in a brief manner.
I think both the parties will be knowing the facts. I don't think you could waste the time on this.
Indeed, Your Lordship. The council then seeks permission to begin with the issue 1.
You can go ahead.
Your Lordship's issue 1 pertains to whether a second Section 7 application is barred by law. To prove my arguments, Your Lordships, the council would be relying on two limbs, which are A, that the second application is maintainable when the earlier application was dismissed on a statutory bar and not on merits. And B, Lordships, that the continuous acknowledgement of liability kept the debt alive, making the second filing legally valid. Your Lordship, it is respectfully submitted that the IBC does not bar the filing of a second Section 7 application. Your Lordship, Section 7, Clause 1 clearly states that a financial creditor may file an application when a default has occurred. The code does not restrict how many times such application may be filed. What matters, Your Lordships, is the
Isn't
fact that
1
there
minute,
should be...
counsel?
Indeed, Your Lordships.
The theory of res judicata is
Indeed,
a
Your Lordships.
universal principle. It's the first principle.
Indeed, Your Lordships. Indeed, Your Lordships.
You will have to show us a provision of law under the code which
Indeed.
exempts such res judicata, because res judicata is an assumption.
Your Lordships, that
Not the other way around.
Indeed, Your Lordships. Your Lordship, regarding the argument of res judicata, the council humbly submits that res judicata applies when a matter has been heard on merits, Your Lordships. The council,
Yes, it has
first
been
issue-
dismissed.
Indeed, Your Lordships, but Your Lordships, in this matter, Your Lordships, the matter has been dismissed because of a Section 10A bar, Your Lordships.
Correct. That's
Lordship-
on merits, isn't it? Section 10 is merits. It's not for default.
Your Lordships, the council mentions the fact that when we talk about Section 7, it expressly mentioned that the court or the educating authority, the NCLT, will actually accept an application based on two things. Firstly, that there should be an existence of a default and the debt should exist, Your Lordships. Lordships, these two are the prime... Your Lordships, these two are the prime criteria, Your Lordships. Your Lordships,
Let us see. Go to 7.
Indeed, Your Lordships. Lordships, if I may refer to Section 7, Clause 5, in that, Your Lordships, it clearly mentions the grounds for rejection of an application, Your Lordships. Lordships, so under Section 7, Clause 5, if the educating authority is satisfied, then an
Can we,
application...
1 minute, Mr. Counsel?
Yes, indeed, Your Lordships. Indeed, Your
Your
Lordships.
rejection of an application is
Indeed.
after you file an application, correct?
Indeed, Your Lordships.
No. So first go to the filing of the application under subsection 1.
Indeed, Your Lordships.
Read.
Your Lordships, it talks about a financial
Read.
creditor.
Don't say what it talks. Can you hear
Indeed,
me?
Your Lordship. Yeah, indeed, Your Lordships.
Please read what it says.
Sure.
Read loudly.
Indeed, Your Lordships. A financial creditor, either by itself or jointly with financial creditors or any other person on behalf of financial creditor, as may be notified by the central government, may file an application for initiating CIRP against a corporate debtor before the educating authority when a default has occurred, Your Lordships.
Pause.
So, Lordships,
Pause.
Indeed, Your
Pause.
Lordships. Indeed.
All that the section provides is that you will file an application when a default has occurred. Correct?
Correct, Your Lordships.
Now, therefore, it means you file an application.
Indeed.
Now, please see that the language employed by the statute does not say whenever a default occurs, but says
indeed, Your Lordships.
There is a difference between whenever a default occurs and when a default occurs. Right?
Indeed, Your
Therefore,
Lordship.
for every default, can you run to us?
Your Lordships, the council would prove that there has been a default. Your Lordships, that the opposite
Who's
council
denying
would
that?
also. No,
Who's
Your Lordship,
denying?
the default is not actually in a state of a deniable, Your Lordship. It is an undisputed fact that a default has
Therefore, why
occurred.
are you saying that?
Pardon, Your Lordships?
The factum of default is not denied by the corporate debtor. Correct?
Indeed, Your Lordships.
So you don't have to go into establishing that there is a default. Default is accepted.
Indeed, Your Lordships. I get it, Your Lordships.
Question is whether every time he makes a default, you can come to the court.
Indeed, Your Lordships. To answer your question, Your Lordships, that Your Lordship, this default is a continuing default. Your Lordship, there has been a continuous acknowledgement of debt by the corporate debtor. Your Lordships, if I may refer you through the proposition, it has been mentioned that from
Why are you going to the
2017.
proposition, Mr. Counsel? Have you convinced us on the statute to go to a proposition?
Indeed, Your Lordship, the council
You
will
were
first go to
you
the
read
provision.
5-1, 10-1,
Indeed, Your
7-1. You wanted
Indeed, Your
to
Lordship.
take me to 7-5.
Indeed, Your Lordship. The
Given up
council
your
will.
7-5 argument?
Pardon, Your Lordships.
You were trying to argue 7-5 before us. I
Indeed,
asked
Your
you to
Lordship.
see 7-1. Now you are
Indeed,
going
Your
to
Lordship.
your proposition. Does it
Yeah,
mean
Your
that
Lordship.
you've given up your argument on 7-5?
No, Your Lordship, the council will connect the facts with the appropriate provisions, Lordships. If the Lordships give me a few time to just elaborate on my arguments, the council will prove that Your Lordships, a default. The council will prove, Your Lordship, that a default. This default is a continuous acknowledgement, and hence, Your Lordships, the default is not a dispute. What is dispute is, Lordship, that because Your Lordship, the debt existed during that time period, and there was a mere technical error on our part to mention a wrong date of default. And Your Lordships, the date of default is not mandatory. Hence, Lordships, the council will take you to the provisions.
One minute.
Indeed, Your
What
Lordship.
did you say?
Your Lordships, the council will take you through the provisions and connect you
Please,
with the
what
facts.
did you say before that?
Your Lordships, there has been a continuous acknowledgement of debt. And
After
hence,
that,
Your
you said
Lordships,
something. That you need not specify the date of default, is it?
Indeed, Your Lordships.
That's the law.
Your Lordships, it's a procedure.
That is the law.
Council, Your Lordships,
Is
the
that the
council
law?
respects the procedure.
Mr. Counsel,
Your
why don't you answer our questions, please?
Your Lordships, it's a procedure that should be followed. That during an application, a date of default under Form 1, Part 4 is mandatory. It should be there, Your Lordships.
Then?
Your Lordships, what the council will submit, Your Lordships, is that, Your Lordships, because, Your Lordships, under Section 7, Clause 7, Your Lordships, if we see, Your Lordships, the Clause 1 itself, the mere necessity is that a default should be there, Your Lordships. Lordships, if I then take you through the 7 Clause 5, the grounds for default, the grounds for rejection of an application are mentioned, Your Lordships. That if the educating authority is satisfied that a default has occurred, and secondly, that there has been no disciplinary proceedings pending against the interim resolution professional, or, Your Lordships, that
why are you creating needless ghosts, young man? Who is going into all those? Those are not at all in controversy.
Indeed, Your Lordships, which is what I am mentioning, Your Lordships, that any of the ground of the rejection is not based on the date of the default. The date of the default, Your Lordships, does not mention as a criteria for the application to be rejected.
Where do you get that proposition? Please convince me. I'm not at all convinced on that.
Your Lordships, the council.
You're saying that there's no law of limitation.
No, Your Lordships, the council will prove that even our application was within the limitation period. Lordships,
please listen before you answer.
Indeed,
or I'll stop asking you questions. I'll mark you. Which of the two do you want? I'll give you the choice.
The council will humbly listen to the questions posed by the.
The question is this. You said that the date of default is not a mandatory requirement. I beg to disagree with you on that, because the date of default is crucial for the purposes of determining limitation. Now,
Indeed, Your
tell me,
Lordships.
how do you get over it?
Your Lordships, if I take you through Section 7, Clause 4, Your Lordship, the NCLT will admit an application, will tell about rejection or accepting an application within 14 days, and it verifies it that an application is accepted or rejected based on the evidences, Your Lordship. The documents are the necessary
Kindly
criteria.
go to the form by which you file an application.
Indeed, Your Lordships.
Take me through the form.
Your Lordships, if the bench agrees, I will, Your Lordship, present it through my researcher. We have actually in our compendium presented the form. So if the bench allows, I will
Yes,
request the researcher to present the form.
Put it on the screen.
Indeed, Your Lordship.
1 minute. Pull out the form. Application under Section 7. This is form what? Form number?
Your Lordship, is Form 1. In the Part 4, Your Lordships, it has been mentioned that a default has to, the amount of the default has to be specified, and also the date of the default need to be mentioned, Your Lordships.
Then,
and Lordships,
then,
the
then,
council, Your Lordship, the council respects that, and hence a second application with the correct date of default is actually submitted before this honorable court, Your Lordships. The council respects the procedure.
That's begging the question, isn't it?
Your Lordship, the council accepts the procedure, Your Lordship. The council is not even saying that a date of default need not is mandatory.
That is what you said 5 minutes ago.
No, Your Lordship, what the council is, Your Lordship, stating is a default is mandatory. Your Lordship, the date of default is a procedure and should be followed. The council will respect that, and hence the Lordships, the council has actually in the second application filed it through.
Okay,
Lordship,
continue.
Your Lordship, the council will also cite a case, Your Lordships. Your Lordship, in the case of Jokon Infra Private Limited.
Please, council.
Indeed, Your Lordships.
I would suggest to all you youngsters, please, tell us what the facts are. Tell us what the law is. 1 minute. My brother judge told you that it is not necessary to state the facts. You will only have to connect the dots, show us how your facts relate to the law on the subject. Why are you in a tearing hurry to show us the judgments? Who are you citing the judgment to? Who are we? To whom are you citing this judgment?
Your Lordship, before the bench of Honorable Supreme Court.
Of the Supreme Court?
Indeed,
You're showing me a judgment of how many judges?
Your Lordship, the bench comprises of a judicial member and a technical member, Your Lordship.
Oh, that was binding on the Supreme Court, is it?
Your Lordship, is a bench of NCLT, Your Lordship, that decided
this. Is that binding on the Supreme Court?
Indeed not, Your Lordship.
So why are you breaking your head and repeatedly telling us you'll go there? First, take us through the legal provision, show us that there is no bar, and then if you want to buttress it with the fact.
Indeed,
yes, proceed.
Council will...
court officer? Vaishnavi, yes, I think I have taken most of his time, so extend his time by another 5 minutes at least.
Of course, that is appreciated, sir.
Go ahead.
Indeed, Your Lordships. Your Lordship, the facts of this case was that Jokon Infra Private Limited actually filed for a CIRP against Brij Gopal, who is the corporate debtor, under IBC for unpaid dues. Your Lordships, and it was dated December 13, 2021. Your Lordships, for which the payment was due on January 12, 2022. The Honorable NCLT in this case admitted an application without any explicit default date. Lordships, holding that where the record clearly demonstrates the default, the petition is complete. And hence, Lordships, the council respects the procedure. The council respects the fact that the date of default should be there as a procedure under Form 1. However, Lordships, the council mentions that in the provision of the Section 7, under Section 7 Clause 1, Section 7 clause 5, where the grounds for rejection of an application are mentioned. In that, Your Lordships, the mere necessity is a default which need to be established. Hence, Your Lordship, date of
Counsel,
default.
1 minute, please. Hold
Indeed, Your
on.
Lordships.
Says Court Officer, I don't see your pro forma mark sheet. Can you send one to me afresh?
I'll do that, sir.
Please continue.
Indeed, Your
Continue,
Lordship.
Counsel.
Lordships, firstly, beginning with the first issue where the council held that application was dismissed on a statutory bar. And Lordships, when we talk about Section 10A, Lordships, it prevents the filing of application between the period of 25th March 2020 to 24th March 2021. If I may take you to the Lordships to the provision of Section 10A, it has
Not
been mentioned.
necessary.
Indeed, Your Lordships. Your Lordships, Section 10A mentions that no application can be filed between this period. Your Lordships, but Your Lordships, it has been mentioned that many companies were actually going into a insolvency, and hence Lordships, and this provision was enacted in order to Your Lordships make sure that the company revives, and hence Your Lordships. The aim of this section was to revive Your Lordships. However, Your Lordships, Section 10A.
Where do you get it? Where do you get that?
Your Lordships, has been mentioned in the proposition itself, Your Lordships, that
What?
the aim of the IBC, Your Lordships, was that a lot of companies during the COVID-19 pandemic were going into a default, and Lordship, in order to make sure that Your Lordship, they are a bundle of applications which were filed, so Lordship, in order to prevent that, Section 10A bar was imposed.
That is arithmetically or logistically or thematically or semantically equal to reviving, is it? Where did you get the revival theory? All that 10A did was it granted an eclipse for a period of 6 months starting on the March 25th of 2022. Correct? It did nothing more, nothing less, nothing else.
Indeed, Your Lordships. Your Lordships, just the council wanted to mention what's mentioned, but it's fine. Your Lordships. So, Your Lordships, but Your Lordships, when we actually go to the explanation which has been added to Section 10A, Your Lordships, it mentioned that any default which occurred before the period of Section 10, before the period of COVID-19 pandemic, which prescribes the prohibition of Section 10A bar, Your Lordships, any application filed before that period will be maintainable, Your Lordships, and the Section 10A bar will not be applicable to the period before the set period of 25th March 2020 to 24th March 2021.
Correct. That is why.
Indeed.
That is why the dismissal of the earlier petition is res judicata.
Your Lordships, the council has mentioned the date of the default wrong. However, Your Lordships, through the necessary documents and evidences, Your Lordships,
so we'll go into that in a second application.
Your Lordships, indeed, Your Lordships, because in the second.
Can we go into it?
Your Lordships, the council
has made. If
Indeed.
the fact scenario on the basis of which your first Section 7 application was dismissed, it was not dismissed for default. Let us assume it was dismissed on a set of wrong facts. Fact remains that it was dismissed.
Indeed, Your Lordships.
Now can we revisit the same? That's all.
Indeed, Your Lordship. Lordship, what the council is mentioning that default is never in question, Your Lordships. So, Lordships, mere technical error, the council humbly submits that mere technical error, Your Lordships, should not compromise the fact of substantive justice, Your Lordships. Your Lordships, the fact that, Your Lordships, default has been proved, Your Lordships.
We are dealing with an expropriatory legislation, isn't it? It's a recovery legislation. We'll have to give it strict meaning.
Indeed, Your Lordships, but
we can't give it liberal construction. No, it's not a welfare legislation.
Your Lordships, when we talk about the objective of the IBC, Your Lordships, it was a time-bound resolution, Your Lordships. Lordships, the council humbly would mention about the case Your Lordships, in this case, Your Lordships, the case name is Srimati Rani Kusum versus Srimati Kanchan Devi. If Your Lordships permit, our researcher would be presenting it. Your Lordship, in the compendium, Lordship, in this case, it was mentioned that all rules of procedure are handmaid of justice. The objective of prescribing procedure is to advance, not to obstruct the cause of justice. Your Lordships, the council humbly submits that there has been a technical error on the part of appellant, and Your Lordship, the council accept that, and hence, Your Lordship, a second application is just, Your Lordship, in order to correct that and respect the procedure, the council is submitted the second application, Your Lordship, with a clear and correct date of default. Your Lordship, the date of default is a procedure, and the council wants to respect it, and Your Lordships want to correct the date. And Your Lordships, it's not based on our whims and fancies, Your Lordships. The council, through the necessary documents, proved that the date of default date was the date of NPA, the non-performing
Council,
asset, which was indeed, Your Lordships.
do you want me to hear you or read? Which of the two? It's a digital reading, isn't it? I have to digitally read the judgment.
Yeah,
So do I listen to you or do I read that? I'm incapable
Lordship,
of doing both simultaneously.
Your
You
Lordship,
give
the
me a
council,
choice. You want me to hear you? I'll hear you. You
indeed,
want
Your
me
Lordship,
to read
no.
your citation? I'll read the citation. Which do you want?
Lordship, the council humbly prays that the bench listens to my arguments first. This is mere, Your Lordship, for facilitating the para that the council submits. That
I have
the rules of
understood your
procedure.
argument.
Indeed,
Your
Your Lordship.
argument is give it a liberal view
Yeah, indeed, Your Lordships.
and is only
And
a
Your Lordships,
technical error.
indeed, Your
On
Lordships.
the basis of a technical error, my case can't be debunked. Correct?
Indeed, Your Lordships. This
Now
is my
show me the
humble.
law.
Indeed, Your Lordships. Your Lordships, under section, Your Lordships, now coming on to the.
You are showing me the
Lordship,
citation, sir.
indeed, Your Lordships. Your Lordship, citation of this case. Your Lordships, am I audible?
Yes.
Yeah, Your Lordships, the citation of this case.
Go ahead.
Hello.
I can hear you.
Yeah, Your Lordships, Lordships, in this case, Lordships, this matter was a civil appeal, and Lordships, in this case,
arising out of an amendment to the Civil Procedure Code, where a 90-day period was given for filing of written statement. Court said that 90-day period can be resolved.
Indeed, Your Lordship. The council will.
To your case.
Your Lordships, in this case, Your Lordships, it was a dispute concerning the proceedings under Order 21, Your Lordships, of the Civil Procedure Code. Your Lordships, during the execution of this decree, Your Lordships, an objection was raised by a third party in possession. And Your Lordships, the matter was that actually, Your Lordships, that when the matter reached the High Court, Your Lordships, the High Court reversed this review, Your Lordships, stating that the application, Your Lordships, the executing court actually treated the applications as premature and dismissed it, holding that resistance or obstruction must actually occur before such an application can be entertained. However, Your Lordships, the High Court actually reversed this view. And Your Lordships, Your Lordships, and then when the matter actually went to the Supreme Court, Your Lordships, the Supreme Court held this thing that all rules of procedure are handmaids of justice. Lordships, the council respects the procedure, and hence, Lordships, through this case, the council wants to state that the facts are the similar. Lordships, the procedure in this case also, Lordships, the application was rejected as stated as premature. However, Lordships, through the facts and evidences and documents, Lordship, it was proved that a default has occurred, and the Supreme Court admitted this application. If your Lordships are satisfied, the council will begin further.
If I'm not satisfied, what will you do?
Lordships.
Proceed.
Indeed, Lordships.
Proceed on the assumption that we are satisfied.
Indeed, Lordships.
And don't threaten us with conditions. Proceed.
Indeed, the council will make sure of that. Lordships, in our, Lordships, in our case, the the limitation period bar won't apply, Your Lordships. Lordships, the limitation period is an, Lordships, the period of limitation has been clearly mentioned. If Your Lordship, the council may request to just extend the time a little bit so that the council humbly submits this point as well.
Court officer, please do so.
Much obliged, Lordships. Lordships, the period of
3 more minutes.
limitation. Indeed, Your Lordships.
3 more minutes.
Indeed, Your Lordships. Your Lordships, the council humbly submits that the period of limitation is 3 years as mentioned under Article 137 of the Limitation Act. And Your Lordships, that Article 137 is applicable in our IBC through Section 238A, which talks about limitation. Your Lordships, the limitation period is 3 years from the date of the default. Your Lordships, the council has proved, Your Lordships, that the date of default is the date of the NPN, the not performing asset, when the corporate debtor, since the default for the period of 90 days has not paid the debt, and hence, Your
Counsel,
Lordships,
let me ask you one question.
indeed, Your Lordships.
The corporate debtor, I'm just asking you a hypothetical question.
Indeed, Your Lordships.
He commits a default on the basis of which you declare him as an NPA and
Indeed.
you initiate proceedings against him.
Indeed,
Right?
Your Lordship.
Notwithstanding this, or a prior to this, you also initiate proceedings under Section 14(4). You're entitled to do that? You do that.
Your Lordship, the council is Lordship, the council want to refer to Section 14 clause 4
of the Surface Act.
Your Lordship, the council is not aware of the provision, but Your Lordship.
Okay, you can bring the property to sale. You can take the property for lease. You can have somebody appointed to run the company, etc., etc. You can do under Section 14 of the Surface Act. Now, let us assume for a minute that you had taken steps under Section 14 of the Act.
Indeed, Your Lordship.
Then the creditor says, no, sir, I will pay up the money.
Indeed, Your Lordships.
And you agree to it, and then he commits a default.
Indeed, Your Lordship.
Notwithstanding the default, you move an application before the NCLT.
Indeed, Your Lordships.
Again, he commits a further default of the payments that are due on the basis of which the case is going on. You'll file one more petition, is it?
Indeed, Your Lordship, it's a continuing default. If we see,
so continuous limitation, you'll keep filing 10 cases.
Your Lordship, indeed not, Your Lordship. The council has filed the application based on that default only which occurred. Your Lordship, in this case, Your Lordship, in the hypothetical situation as well, the principal amount will remain the same. Your Lordship, the interest may differ. However, Your Lordship, the debt will remain the same. The debt has occurred. Your Lordship, even Your Lordship, the council humbly submits that, Your Lordship, the ABC Bank, Your Lordship, is a public sector bank. Even, Your Lordship, we want the corporate debtor to pay our debts. We don't want to tarnish their reputation.
If you're a public sector bank, what happens?
Your Lordship, the amount, Your Lordship, the money is of the public, Your Lordship, which is, and Lordship, the amount is.
1 minute. So what? Please, I'm not your collection agent.
Indeed, Your Lordship.
My commitment is to the rule of law, not to the amount due to the exchequer.
Indeed,
Let's get this theory very clear. Judicial bodies are... Give him another 30, 40 seconds after I finish. Quasi-judicial, judicial bodies' commitment is to the rule of law, not to the exchequer. Please get that clear. Now proceed. And don't tell us this much of money, public money, all that. You should have been careful. Audit your bank properly.
Indeed, Your Lordship.
Get the man who allowed this check to become a default, this loan to become a default. Audit him, not the law.
Indeed, Your Lordships. Your Lordships, through this, the council just wanted to submit that even, Your Lordships, the bank wanted a resolution, Your Lordships. The bank does not want to tarnish the reputation of corporate debtor, Your Lordships, and want the matter to be dragged before this honorable court. And Your Lordships, the council also wants that the money to be paid back and hence, Your Lordships, the council was referring to the public one. Now, Your Lordships, that's all my submissions are, Your Lordship. Now, my co-counsel would be dealing with issue 3 and 4. Much obliged, Your Lordships. It was a pleasure arguing before you.
Just one more question for you.
Indeed, Your Lordships.
ABC is a financial creditor, right?
Indeed, Your Lordships.
Where do you get it that it's a public sector bank?
Lordship, it's mentioned in the proposition.
Court officer, can you just confirm that for me? That it's a public sector bank? Not that it makes a difference. I want to know for a fact.
Yes, sir. It's mentioned in para 1.
All
first
right,
line.
then go ahead. Go ahead.
Public-
Yes,
public-
we'll go to speaker number 2.
Yeah, Speaker, I got Council 1. I got a question for you.
Indeed, Your Lordships.
Now, can you change the dates of your convenience? Suppose you lost the case in first round and you come with the second application with this different date.
Your Lordships, Your Lordships, we are not actually, the council humbly submits that we are not changing the dates based on the convenience. The council please and humbly submits that the date of default earlier mentioned was just a technical error. And Your Lordship, through the records, it has been mentioned that the date of default was the date of NPA. Which was before the COVID-19 pandemic period. Hence, Lordship, the council just humbly prays before this honorable court to please ignore the technical or mere error because the default has been established, Lordship, which is the prime criteria in order to prove, Your Lordship, that a corporate insolvency resolution proceedings has to be initiated.
No, you're not bona fide in changing that. Because of this COVID, you took the advantage and changed the date again, filed a second application. What is wrong in this?
Pardon, Your Lordships?
No, you have changed the date, taking the advantage of the COVID situation, whatever the dates mentioned in the tabular form. You subsequently filed an application with, you're not bona fide on that.
No, indeed not, Your Lordships. What the council is stating is that, Your Lordships, if Your Lordship, there has been no, if Your Lordship, there would be no documents, though no evidences, Your Lordships, to prove, to justify our date of default of the second application, the council would never actually go for a second application, Your Lordships. However, Your Lordships, because the evidences, the acknowledgements by the corporate debtor clearly proves, Your Lordship, that default date was much prior, and just because of our technical error, Your Lordship, the bank...
That is exactly the question that my brother is asking you. Whether the error is technical, just technical, substantially technical, effectively technical, are all adjectives. Can you do it is the question.
Your Lordships, the second application is permitted. The courts have allowed a second application, Your Lordships, based on different facts. However, Your Lordships, so second application is not barred by law, is my permission, Your Lordships. And because it is not barred, Your Lordships, the council wants to actually mention a correct date of default in order to just correct and respect the procedure, Your Lordships. This is my humble submission.
Let me ask you another simple question. You file a suit for the declaration of title, recovery of money, civil suit.
Indeed, Your Lordships.
Suit dismissed. You file one more suit, is it?
Indeed not, Your Lordships. Lordships,
that is the question we are asking you, no?
Indeed, Your Lordships.
Yes, we are eager to hear your colleague.
Yeah.
The bench.
Yes.
Am I audible, sir?
Yes, you are.
Yes.
I am speaker number 2, and I'll be dealing with issue number 3 and 4 for this matter, my lords. Issue number 3 states that whether or not the date of default changes based on the facts and circumstances, or it is to be taken as the date of NPA in all bank matters. Under the issue, my lords, I majorly have 2 submissions. Coming to the first one, that NPA declaration is a statutory trigger for default under Section 3, Clause 12 of the Insolvency and Bankruptcy Code. If I may take my lords to Section 3, Clause 12 of the Insolvency and Bankruptcy Code, it states that default means non-payment of a debt when whole or any part or installment of that amount of debt has become due and payable and is not paid by the debtor or the corporate debtor, as the case may be. Now, my lords, in banking sector, the first legal recognition of a persistent non-payment of the account as an NPA under mandatory RBI prudential norms. These norms, my lords, are not discretionary. They are statutory directions issued under the Banking Regulation Act. When an account is classified as NPA, it is only after a 90-day window, 90-day continuous default, meaning that the bank has already determined that the borrower has failed to discharge dues that were unquestionably payable. Thus, my lords, the NPA date
Counsel,
is not
correct me
merely
if
a...
I'm wrong.
Yes, my lords.
The default becomes the day on which clause 12 applies.
Yes, my lords.
There is no holiday of 90 days there.
Yes, my lords.
The 90 days is a corrective window given to you.
Yes, my lords.
For the corporate debtor, a 90-day holiday is given. That's all. If the
Yes,
90-day holiday is not made use of, it dates back to the date of the default.
yes.
In any event, it is not a holiday given to the creditor,
Yes, my
to
lords.
the corporate. It's only for the corporate debtor, not to the creditor. Where did you
Indeed.
get that 90-day period?
No, we have given that 90-day period as a creditor.
Thank you very much. He will tell you, but where do you get it for the purpose of limitation is the question, no?
Indeed, my lords. The 90-day window, we are not questioning that it is counted for limitation. What we are saying
Then why are you
that
telling us that?
NPA classification,
You're
the NPA
teaching us the law
classification.
now.
No, no,
What
my lords.
term?
No, no, my lords. We are
Ah.
not teaching anything. What we are submitting it that the NPA was a legal recognition that now the default has been legally recognized under the banking
No,
regulation.
that is what I'm telling you.
Yes, my lords.
The default is recognized on the day subsection 12 occurs. You keep your
Yes, my
hands
lords.
off for 90 days, that's all.
Yes, my lords.
The
But
clock begins to strike not after 90 days. The clock begins to strike on the date of the default.
But my lords, what the council is trying to submit is that after that 90-day window only, that date has a legal recognition under the prudential norms.
All right.
Now we have a legal recognition that using that date we can proceed further. Is my humble submission.
Correct.
My lords, this NPA date is not merely a bookkeeping entry; it's a formal regulatory acknowledgement of the first point of non-payment. Is what I'm trying to submit.
What?
This date or default at this time becomes a concrete form.
I
Is
like
what the
that
client.
expression. That is why I'm asking you again.
Yes,
Repeat
my
what
lords.
you said.
The NPA date is not merely a bookkeeping entry; it's a formal.
Correct. Therefore, the crucial date is not a bookkeeping entry. It is the date of default, not the 90-day period.
Indeed, my
Thank
lords.
you for
But
using that expression.
yes, my lords. But since now it has got a legal recognition under the norms,
Till that date,
it
it was a
can be used.
bookkeeping entry, sir.
No, my lord, it is not a mere bookkeeping entry. It
Okay,
is a legally recognized date of default.
Proceed.
My lord's court have also repeatedly emphasized that for limitation purposes under IBC, what matters is when default becomes identifiable in concrete form. The NPA classification serves this precisely, which provides the earliest documented evidence of default, far more reliable than any bank records for the fluctuating payment schedules. Therefore, my lords, treating this NPA date as a date of default fully aligns with Section 3, Clause 12, complies with the RBI's framework, and prevents a situation where borrowers escape insolvency proceeding merely by disputing this earlier unpaid installment. My lords,
And bankers will make mistake on that date while making applications.
My lords, that was a technical error and we duly accepted, my lords.
You're telling me it's not a bookkeeping thing. It's the holiest thing. We are giving respect to the holy thing.
Yes, my lords.
Holy cow. We are respecting it. No, now how do you come back and say it is not as holy as you want us to believe?
My lords, what we are saying is the first application, which used us 2020 date, was an error. And now we are rectifying that mistake and we are filing a new application stating the original date.
Let me ask you one question. In 2020,
yes,
was there a default or was there no default?
There was a default, my lord.
Then how is it a mistake?
My lords, that default date was the failure of the OTS payment. The original default, my lords, the
Oh,
original
so
loan
now we will
credential
start
dates back
looking
to
at
2014.
so we will now start looking at various headings also for default.
No, my lords, but the acknowledgement that OTS was merely an acknowledgement which was also defaulted.
Proceed.
The, my lords, this statutory interpretation, my lords, is also further forfeited by authoritative pronouncements of this Honorable Supreme Court in the case of
What? Statutory?
this interpretation, what the Council have submitted, my lords,
Which
of Section
indicate?
3, Clause 12, that this NPA date could also be classified as a date of default.
Which citation?
Babulal Vardharaj Gurjar versus Veer
Run it
Gurjar
on the screen
Aluminium.
for us, please.
Please, my lords, the researcher will run it for you. Kind person. It is a 2020 judgment, my lords, where court held that the date of NPA is a valid and
Court or
acceptable date
tribunal?
of default. Court, my lords, Supreme Court judgment.
Let's see.
Please.
Your time will be frozen, don't worry.
Much obliged, much.
Yes, this is what I told you. See what is underlined there. This is exactly what I told you.
Yes, my lords.
Hmm.
My
You
lords,
have the 90
this is
days.
what I'm trying to submit, my lords, is that court also recognized that NPA date could also be classified as date of default for the matter of under Section 3, Clause 12 of the IBC.
Then show me that judgment. Why are you showing me this?
Please, my lords. The relevant para has been added, my lords, under Section 7 of the Code of Default to be the date of NPA. That is in this particular judgment only, my lords, the date of NPA was also was
Can
regarded as
I
a date of
kindly
default.
request you to please take me to that paragraph? First, take me through the facts of the case on top. Take me to para 1.
We actually,
Yeah,
I'll try, my lords.
No, go back. Facts. Respondents and with. Yes, go down. Scroll down. Scroll down. Stop there. Yes, which is the proposition you want us to read? Over here,
Yes,
which is the finding?
Yes, Lordship. The conclusive finding was this, my lords, that under Section 7 also, the NPA date is also considered as date of default. This is the
Where
final
do you
submission.
get that, I say? Read it, no?
For the benefit of the court, should I read the facts, the summarized
No, read
facts of this
the
case?
finding. Because what is underlined is what I have been saying.
That is what, my lords. Under Section 7 of the code, the date of default is to be the date of NPA. That is
Correct.
what I
That's
also
all is
submitting.
what I said half an hour ago.
Yes, my lords. That is what I am saying, my lords, that the date of default can be considered as date of NPA.
Date of default as defined under the statute. Clause 12.
Yes, my lords.
Okay,
Yes, lordship.
continue. All right, continue.
The second submission under this issue is that in commercial laws, the doctrine of certainty is foundational. My lords, business lenders, tribunals depend on a clear and documented, consistent benchmark for determining rights and liabilities. My lords, limitation being a substantive bar is particularly sensitive to this requirement. It cannot hinge on subjective narratives or shifting interpretations. And in banking sector, the only clear objective and statutory regulated date that reflects the occurrence of default is the date on which that particular account becomes an NPA.
Which is
It is
defined
not
under the
speculative.
statute under section 12, the subclause 12.
Yes, my lords. The NPA date is not.
We are not here discussing whether your debt is barred by limitation at all. We are not concerned with that. We are concerned with whether it is barred for the NCLT to consider.
Yes.
Therefore, you are bound by the IBC code, not by the general principle that you told us.
Yes, I'm sure.
Apply the general principle, go to the civil court, file a civil suit, recover the money. Maybe you are right, you will get it. But if you want the fast track route,
yes,
then the fast track physics will apply.
Yes.
Do not take a posh engine and put it into an ambassador car. Doesn't work.
Yes. Sure. The date is not speculative, Manoj. It is based on the norms of the RBI, that the 90 days window and the uninterrupted non-payment thing. Therefore, if the commercial certainty is to be preserved, the NPA date must be treated as a fixed point from limitation runs. This brings to the issue number 4, Lordships, that whether or not a case can be admitted if the default has occurred and the application is well within the limitation, despite an error in the date of default. Under the issue, my lords, the council majorly have two submissions. Firstly, that procedural errors such as an incorrect date of default cannot defeat a substantive right under IBC. And the second submission is that application cannot be rejected merely due to an incorrect default when the claim is otherwise within limitation.
No, we are not saying it is barred by limitation. So why are you bringing up
the issue is that whether or not the case can be admitted. Yes, my lord.
The date that we are all talking about,
yes,
is your creation, not one of limitation. You are saying,
yes, my lord.
You're saying your case was wrongly rejected because you had placed a wrong date. Correct? It is not as if it's an error of the court and therefore it stands to automatic correction.
Yes, Lord.
Based on a certain set of facts projected at your end,
yes,
the tribunal dismissed your case. On facts. On facts.
Not on facts, Lordships. It's only on technical grounds.
Please listen to me completely.
Please.
First round, your case was dismissed on what ground?
That it fall under a 10A bar, which was imposed by IBC.
So that's the law, not on limitation. On law, it was dismissed.
Yes.
You now come back and say that that date which was mentioned as a consequence of which 10A applied was wrong.
Yes. Yes.
Right? Therefore, whether that date falls within 3 years, 2 years is not relevant.
Yes,
question is, you fixed a certain date. Yes. On the basis of such fixation of date on merits, the tribunal dismissed your case. If we correct it now, are we permitting a statutory review where none exists?
Lordships, the second application was also not heard on merits.
That's what I'm saying. Because the first went.
Yes, my lords. We in that case, now,
Counsel, suppose we agree with what you're saying.
Yes.
Suppose we agree. Okay. What does it mean? That the tribunal ought to have corrected it? Correct?
Yes.
Does the tribunal have the power to review its orders?
No, my lords. That is why.
And how do I empower it? The legislation did not want it. We will do it. Is it?
Lordship, the error apparent was on us that we put a wrong date. Now we have rectified that date.
That is why Okay. Proceed.
Yes, my lords. So this first submission that at the heart of this matter lies the fundamental principle repeatedly emphasized by Supreme Court that insolvency and bankruptcy code is a legislation of resolution, not of technical dismissal. The purpose of the code is to revive viable businesses, restructure debt, and ensure value maximization, not to
Did it
defeat
also
process
say it is the purpose of the legislation is to deal with irresponsible bankers?
No, my lords, it is not the case
Say
here.
so and we'll allow your petition.
My lords, the humble submission is that the first application, that the error on the date
Counsel, the problem
done by
is the statute is already diced in your favor.
Yes, my
In
lords.
spite of it, you all do this.
My lords, a wrongful impletion of that date has led to this situation. If on first instance we have mentioned the corrected date, it could have never happened. And we accept our fault on that thing.
Facts, corrections, provision.
My
Yes.
lords,
Yes.
to that, if I may rely on a judgment,
Please show us.
Swiss Ribbons Private Limited versus Union of India.
Show us the citation and the paragraph.
Please.
Because the
It's a
earlier judgment that you
2019
showed us
judgment.
was not in your favor, it was against you. Next one.
My researcher would share his screen.
Yeah.
My lords, if I get 5 minutes to just submit my rest of the arguments.
Yeah, you will. Don't worry about it.
Sure.
Kindly scroll up to the beginning of paragraph 28. Wait. Go up. Come down. Sorry. Come down. Stop there. Come down. Counsel, why are you reading this judgment? Please understand that don't scroll further down, please. Stop scrolling. This was a case where there was a need for a certification. That certification has now been done away with in view of what Justice Nariman holds in the above paragraphs.
Yes.
It is in that context that the court said, you don't wait for the certificate, you go ahead with the admission of the matter automatically. That was not the intent of this judgment, is not to make a postman out of the tribunal. There's no automation there. The automation is in the context of the scroll up a little more, please. Scroll up. Stop there. Go up a further little more. Go up. Now stop there. Stop there. A further technical corporate affairs, this needs to be corrected. A further technical violation also exists that if the powers of the High Court are taken away, NCLT is the appellate forum, which should have the convenience and expediency as with prior appeals to the NCLAT. Since NCLAT is an appellate authority, has only work in Delhi, Scroll down. Stop there. Rule 4.3, the applicant is to dispatch a copy of the application filed with the adjudicating authority by registered post or speed post. The speed with which the adjudicating authority to ascertain the existence of a default from the records of the information utility or on the basis of the evidence furnished by the so-and-so is important. That was in the context of that certification that they said this. Okay,
Yes.
go ahead.
So
Next.
that is where my lords, the council is trying to establish a link that
Ah.
is also a technical formality. The date is also a technical regulation, and the overall substance based on this technicality should not be overlooked.
Okay.
Is what I'm trying to submit. The council
Are
is
you
just trying
saying
to
that the
connect the dots in that
tribunal
sense.
has no power to correct a technical error? Why did you file a fresh petition then?
My lords, we filed a fresh petition only so that we would come out with the clean hands and
Well,
it
if it's
prevent
only a
prejudice on us.
technical error, you should have asked the tribunal to correct it.
Yes, my lords. That is what, my lords. The appellant in this case then must approach the NCLT with a. We have to follow the procedure in that sense. And in a good faith, we filed a fresh application altogether. So that's uh, it ensures transparency and prevent any further allegations of manipulation of documents. That is why we came up with a fresh application. If that has answered my lord's question, I would like to
Yes,
proceed with
yes,
further.
yes.
My lords, Section 7 of the IBC also requires that the educating authority to determine the Section
Just
7
give me 1
application
minute, please.
broadly.
Just a minute.
Please.
Yes, go ahead.
Please, my lords.
Mm.
The Section 7 of IBC requires adjudicating authority to determine the things broadly on two sets of regards, that whether financial debt exists, yes, it is, whether the borrower has defaulted in the payment of the debt, which in this case they have. But the statute doesn't require the tribunal to conduct a microscopic or punitive examination of these pleadings.
Counsel, tell me this.
Please.
Suppose we allow your petition.
Yes.
Will it amount to overruling KV Ram Reddy versus NCLT?
My lords, I am not aware of the judgment.
Okay. Are you aware of Section 422 of the Companies Act?
I can open it if my lords may
Please
permit.
open it.
Which section, my lords?
422.
Of the Companies Act.
Yes.
Yes, my lords.
What does it say?
Every application or petition presented before the tribunal and every appeal filed before the appellate tribunal shall be dealt with and disposed by it as
422.
expeditiously.
420
Yes, my lords.
subclause 2.
Subclause 2, where any application or petition or appeal is not disposed of within period specified in subsection 1. That
1 minute, please. Correction, whatever. Rectify mistakes. 1 minute. 420. Yeah, that's what I say. Section 420 of the Companies Act,
just a second.
subclause 2.
The tribunal at any time within 2 years from the date of the order, with a view to rectifying any mistake apparent from the record, amend any order by it, and shall make such amendment if the mistake is brought to its notice by the parties.
Why didn't you apply this? Why did you file a fresh petition?
My lords, we filed a fresh petition to appear with a clean hand for this purpose.
Why?
We
This
don't
is dirty hand.
prejudice.
422 is because 420 means dirty.
No, my lords, to prevent any further prejudice. We wanted that clear records for that purpose should be given to us.
Okay. Okay.
Lords, this brings me to the last submission. under issue number 4 that application cannot be rejected merely due to an incorrect default when the claim is otherwise within limitation. It is respectfully submitted that limitation in the IBC operates independently of any incorrect, imperfectly stated default date in the application.
You have a
What is
citation for that?
My lords, to further this, I have a citation of BK Educational Service Private Limited
Let
versus
me see that.
Parag Gupta and Associates.
Let us see that.
Please. Lordship, if I may get another 1 minute to just
Yeah. Take 1 more minute.
If my lordship have read, can I further with the submission?
No. Wait, it's clear. How does this help you?
Through this judgment, my lords, what we are trying to say that under IBC, the decisive question is not the precision of default date pleaded, but whether creditor's claim is alive in the law on the date of filing.
I didn't get what you're saying.
My lords, you were saying that whether the creditor's claim is alive in law on the date of filing, and that is how we are submitting that it is not barred by limitation for that purpose, and we still have a right to approach the forum.
See, a human being can die only because of heart attack or for other reasons also.
There are other reasons.
Thank you very much.
So, in the present case, the subordinate debtor has issued multiple OTA settlements that works as an acknowledgement between 2017 and 2022, and this the last failure is within limitation. Is what I'm trying to submit.
Show me in your pleadings where you have said an earlier attempt for recovery was based on this date. For this reason, it was rejected. After that, there was fresh cause of action. On the basis of the said fresh cause of action, fresh default has happened. Therefore, we come within the period of limitation and default under clause 12 and limitation as prescribed under section 7. Show me that.
Lordship, the humble submission to that is that the last acknowledgement, which is in 2020, the default payment, that has acknowledged the prior date, and if we calculate that, the last date of that OTS letter.
I'm so sorry, my
failure.
communication skills are very narrow. I don't think I communicated what I wanted to tell you. Anyway, anything else?
No, I don't have any further submissions.
Thank you.
If my counsel, if my lords may allow, the counsel would like to produce a prayer before this go.
We've seen the prayer. Prayer is to allow your petition can go back to the tribunal for considering the whole case on facts.
Yes, ma'am.
Thank you.
Much obliged.
Thank you. Thank you. They will change it.
Shall I proceed?
Yes.
Yes.
Greetings to the bench. May it please the honorable bench, the council seeks permission to address the bench as your lordships.
Go ahead, madam. Go ahead.
I,
Don't engage in
along
a
with,
minor conversation. No, go ahead. That's all formalities.
pardon your lordship. I, along with my co-counsel, are appearing on the behalf of respondent, that is XYZ Private Limited. Before proceeding, I just acknowledge the jurisdiction of this honorable court, and if the bench is well versed with the facts of the case, the council seek permission to proceed with the issues.
Please proceed.
At outset, I will first establish that why second application under section 7 is barred by law, and then demonstrate that why mentioning a precise date of default is mandatory statutory requirement under the IBC. The council seeks permission to proceed with issue 1.
Madam, 1 minute. We'll come to all that later. Are they barred by limitation?
What, sir?
Are they barred by limitation? What is the
Sir,
date of default according to you?
Sir, 2020.
Huh?
Your lordship, 2020.
What's the date they have mentioned?
It is 1 May 2020.
So what is wrong with that date? If it is 1/5/2020, is the petition maintainable or not?
That particular application falls under the 10A moratorium window period, and hence it was dismissed.
Therefore, it was not dismissed on merits, isn't it?
Sir, it was dismissed on merits only.
How was it merits, madam?
So.
It was a holiday period. They said on... Okay, let me ask you this question.
Your lordship.
A school is closed for vacation.
Yes, sir.
You can't take classes. After vacation, you can take classes of the earlier period subject or not? No. Can't take.
Your lordship.
Law prohibits them.
Your lordship, I certainly agree with what you're trying to say, but...
Oh, I'm trying to say, is it? I'm trying.
No. I'm so sorry. Pardon your lordship. I agree. I certainly agree with what you're saying. I would like to put forth the intention in rejecting the in limine cases. If the case is decided without going into the merits of the case, it becomes difficult for the court to decide what were the factors which weighed for the making the judgment.
That is worse, no? That is worse. On that ground, we can send it back.
But
because the principle of law is that any quasi-judicial order must be a speaking order available for further judicial scrutiny. If it's an in limine order, there's no reasoning.
Yes, your lordship. But if there is a clear...
Madam.
Shall I proceed?
Non-availability of a ticket and refusal to travel, are they the same?
Pardon, your lordship, what did you say?
The non-availability of a ticket to travel and incapacity to travel, are they both the same?
They are different.
That 6-month period, there was no travel right. That's all. You came during that day, we sent you back. That doesn't mean you can't travel.
Your lordship, the main contention of the respondent is that if we allow the change in default of date, the purpose of 10A gets defeated. The objective of 10A, which...
No. The 10A period will be calculated.
Your lordship, if you permit me, I'll demonstrate what I am trying to...
Yeah, please do. Please do.
Your lordship, the application which was filed in the year 2022, mentioning the date of default as 2020, and again which was after losing it, and dismissal got affirmed by the NCLAT. The appellant tried to shift the date of default to 2014, which is a 6-year gap, showing the deliberate reconstruction of the fact to escape the 10A statutory bar. Your lordship, I humbly submit this, that uh, when there is a clear dismissal due to some technical lapses, or by going or without going into the or by going into the merits of the case, then the intent has been clearly
Is
satisfied
the
and the
court
rest
going to the merits of the case?
What, sir? So what, your lordship? I'm sorry.
Did
Pardon.
the court go into the merits of the case?
Your lordship,
Can
the
you read
section.
section 11 CPC?
Yes, yes, your lordship, I will. Section 11 of CPC respectively
That's where
says that,
adjudicator comes, right?
yes, no court shall try any suit or issue in which the matter directly and substantially in issue has been directly or substantially in issue in the former suit between the same parties, or between parties under whom they or any of the claim litigating under the same title, in a court competent to try such subsequent suit, or the suit in which such issue has been subsequently raised and has been heard and finally decided by such court.
Correct. So read what the final says.
Pardon, your lordship?
The subsequent court cannot try which has been heard and finally decided by such court. No court shall try any suit or issue in which the matter has been directly and substantially in issue, been heard and finally decided by such court. According to everybody, it was not directly and substantially decided. All that was decided was you came, the period of limitation was barred by 10A, therefore your petition does not rise.
They're essentials to attract the res judicata to a particular case, your lordship. The parties which should be the same, which is in our case same, the ABC Bank and the XYZ Limited. The subject matter should be the same, which is the same of a rupee 500 crore rupee debt. The cause of action should be the same, which is the default date we're talking about. And the competent court has adjudicated the issue, which the NCLT and NCLAT did so.
Have they done so?
Yes, your lordship.
Where do you get it? They only dismissed it on that ground. They did not substantially deal with it. Okay, let me ask you one more question. A suit is filed. The law, it appears to me, correct me if I'm wrong, is that if there are 10 issues, all 10 issues have to be decided.
Yes, your lordship.
Correct? Is it your case that all the issues were decided by NCLAT, by NCLT and NCLAT in the earlier round?
Your lordship, I would like to put forward it in this way, that the date of default which was mentioned was falling within the 10A period, that is 25 March 2022, 24 March 2021, which essentially freezes the proceeding, of the case. So the NCLAT and NCLT and NCLAT were right in dismissing the petition, because it is the section 10A of IBC.
They are not in
explicitly
appeal
says,
against that order.
yes, yes, your lordship. Shall I continue where I left for the res
Yes.
judicata?
Yes.
What I submit, your lordship, that the parties are same, that the subject matter of both the cases are same, the cause of action of both the cases are same. A competent court has already adjudicated that issue, which means that issue has attained the finality. If your lordship permits, the council seeks permission to present a judgment of Rolta versus Verenium Cloud.
Yes, let us see it.
Just a minute, your lordship. The researcher is on it. The research is on it.
It's going to go down and get a cup of coffee. Yes, how does it apply to you?
It is similar, as it talking about that how date of default cannot be changed at the whim and fancy of the petitioner, which the appellant is trying to do so, just because they
Show me
they
a
lost
finding of the NCLT that the change was on whims and fancies?
Sir, the highlighted part of this order.
Quote, Madam,
Yes, Lordship.
this judgment says that the date of default cannot be changed by the whims and fancies of the petitioner. Correct?
Yes, Your Lordship.
This is very obvious that you can't change it. Where is the finding by the NCLT that the date of default was changed at the whim and fancy of the petitioner? Is there a finding? Because,
Your
one minute, because the logic is,
Pardon, Your Lordship.
the logic is this. Date of default cannot be changed is not what the court said. Court said it cannot be changed at the whim and fancy of somebody. That means it can be changed, but cannot be changed at whim and fancy. Correct?
Yes, Your Lordship.
Where is the finding of the court? The finding whether the date was changed at the whim and fancy of the petitioner is a statement of fact that should be recorded by the tribunal. Where did the tribunal say that it was by whim and fancy?
The fact sheet of the moot prop says so,
Says that the
Your
date
Lordship.
was changed. It did not say that the date was changed at the whim and fancy.
Just give me a minute. Just give me a second, Your Lordship. I'll read it from the moot proposition.
Please read.
The point number 10 says that that the matter came to be dismissed by the Honorable NCLT on the grounds that the financial creditor cannot change the date of default on its whims and fancies, as well as on the grounds of res judicata.
You're right. Okay. Then, now come down further.
Your Lordship, not just limited to this, the constructive res judicatas also.
1 minute. Let us finish with this judgment, no? Or you don't want to? You don't want us to
Pardon, Your
follow this
Lordship.
judgment? We'll skip it.
Pardon, Your Lordship. Pardon, Your Lordship.
Do you want us to rely on this judgment?
Yes, Your Lordship.
Then read how and tell me how is it applicable to you? Under section 11, how is it applicable to you?
Yes, Your Lordship. I'll read it out first, and then I'll try to draw an analogy with our case.
Madam, you've done that already. Please read just that part. Is barred from
as stated above, the date of default cannot be changed at the whim and fancy of the petitioner. Even otherwise, the petitioner is barred under the provision of Order 2, Rule 2 CPC, as well as under Section 11 of CPC, as the matter on the same sets of fact in the respect of the same financial debt has already been finally decided in the previous petition, and the petitioner is barred from taking any new plea in the subsequent
has been
litigation.
finally decided in the previous petition.
Your
It was
Lordship,
not
that is
finally decided. It was decided only on the ground of 10A. One. And secondly, how will Order 2, Rule 2 CPC apply in a case where the default was after the first petition was filed?
default was not after the first petition was filed. Default was in 2020. Your
There are
Lordship.
cases that there are defaults even after that date. Isn't it?
Your Lordship, the Order 2, Rule 2 of CPC mandates that the entire claim which is arising
Correct.
must be.
There was no such claim on that date. Your further default did not happen on that date. Continuous default cannot happen on the date of filing of the plaint, isn't it?
Your Lordship, what I'm trying to put forward
in any
is
event,
that
forget the Order 2, Rule 2 part. Tell me this. That judgment that you're relying upon,
yes, Your Lordship.
same financial debt, same parties, everything is correct. Crucial words, finally decided in the petition.
Yes, Your Lordship.
Explain that for me and then go ahead.
Could you please, pardon Your Lordship, could you please just repeat the last part of your query?
In that paragraph that you read, under
Yes,
Section
Lord.
11 as the matter of the same set of facts in respect of the same financial debt are both correct in your case. But the later paragraph has already been finally decided in the previous petition. Has it been finally decided was the question.
Yes, Your Lordship, the respondent respectfully and humbly submit that yes, it was finally decided because
All right, got it. Go,
the
proceed.
dismissal.
Proceed.
Proceed. Okay.
One more minute for her,
Just
please, court officer.
okay. Okay, Your Lordship. Shall I proceed with the issue second? The council
Yes,
seek pronation.
yes, yes.
The issue second is whether the mentioning of date of default is mandatory under IBC or not. The council for respondent humbly submit that the mentioning of date of default is mandatory in the
Where do you get
application
it?
under IBC.
Where do you get it? Where do you get it that it is mandatory?
Sir, form number 1, part 4 of the
Does the section say so?
sir, the proceed.
Madam, can a form determine the substantive right under a statute? If the statute does not prescribe it, can the form prescribe it? Form is a matter of convenience, isn't it?
Your Lordship, the determining of the date of default is in a way bigger way is related to the case for determining so many things. The date of default determines the limitation
Madam.
period. The date of default.
Madam, show me under, you said it's mandatory. Show me how is it mandatory? Which provision makes it mandatory?
The council seeks permission to present the case law.
Yes.
Asset reconstruction company. Just to add to the last point, Your Lordship, the thing which I missed in the first issue, can I just complete it in a one sentence?
You have 1 minute. You can do whatever you want.
Yes, Your Lordship. I just wanted to add a point that the constructive res judicata also applies to this case because the appellant had the chance to amend their pleadings, amend their the date of default when the NCLT dismissed it, but they decided not to.
Can they do
chose
that?
not to do it.
Can they do that?
They can amend.
That will amount to review.
They can amend the date of default as per
Not
the
after the
ban.
order is passed, madam. Not after the order is passed. That will amount to a review.
While the
and this court has held that the NCLT has no power to review its orders. It can only correct a few errors. Anyway, go back to your second point. Go to your second point and tell me that assets reconstruction company case. You were arguing that, isn't it, about that ASRC case? Though
yes,
you did not give us the citation.
The highlighted part of the relevant judgment is on the screen.
Madam, I'm again asking you, is it that asset reconstruction case of our court? Go to the nomenclature.
Yes, Your Lordship. Yes, Your Lordship.
Go up. Asset reconstruction versus Manyata. Yeah, now tell me the paragraph.
Your Lordship, the 35th para of this judgment, which says that date of default is mandatory concept, mentioning the date of default.
Madam.
Yes, Your Lordship.
What judgment are you citing?
Sir, it's asset reconstruction versus Manyata.
Whose judgment?
Supreme Court judgment, Your Lordship.
Go up again.
NCLT Bangalore.
Sorry, NCLT judgment, Your Lordship.
You want us to be bound by an NCLT judgment?
Your Lordship, the NCLT judgment has a persuasive value before the Honorable Apex Court.
Sorry, madam, it has zero persuasive value. Where do you get that? Persuasive values of a coordinate bench, not of a hierarchically We are hierarchically above them, isn't it?
Your
How
lordship,
persuasive? Then if it is persuasive, all their appeals will have to be allowed.
that's exactly your lordship. The NCLT is a quasi judicial body, and the whatever, it is a very specialized body which has been set up specifically for the IBC, not specifically, but yes, specifically for the IBC proceedings and all the matters relating to the company and the debt. So whatever, since because this quasi judicial body is specialized in this particular area, what the 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 principles or the orders from this quasi judicial body has a persuasive value before the honorable court, because uh, it it provides a very specialized and a more nuanced view of a particular case, your lordship.
Continue, madam.
His lordship. Uh, the highlighted part of the relevant judgment is on the screen, your lordship.
I've seen
The
it.
date of default.
Madam, please don't waste your time by showing us a judgment of the NCLT.
Yes, your lordship. That is what exactly the respondent trying to assert in before the honorable court, that the change in the date of default cannot be allowed. It is mandatory to be mentioned, because the date of default is very important to determine the nature of the very case, because the if the date of default is not mentioned in the mandatory form, then or it is like allowed to be changed, the nature of the whole case changes. Is the lordship satisfied, or have any query for the council? The council is much obliged to answer.
Thank you. Satisfied or not, the verdict will tell you.
It was an honor to argue before you, lordship. The council now respectfully submit the further issue. The council now respectfully pass the
Baton to
third
the
and fourth issue
second
to the
council.
council too.
Yes.
Thank you, lordship.
Council, don't be in tension. Now, what Sir has asked rightly, because now you have to demonstrate before the court that this. No, don't. This happens because you have to, under these tense moments, you have to satisfy the court in better way.
Ma'am, let me assure you, you did a very good job.
Yes.
It's not easy answering questions of the tribunals. We come with a lot of attitude to ensure that you all are nervous, you all become nervy. That's our purpose. It is not that you are not arguing a proper proposition or that you're not arguing very well. In fact, your marks for court manners are very high in my sheet. So there's nothing to be worried about. But be ready that you can be satisfied that this was baptism by fire. Yes, Speaker 2.
Am I audible, your lordships?
Yes.
Yes, please.
May it please the Honorable Court that the Council is appearing on the behalf of respondents in the present matter. The Council seeks permission to address this bench collectively as your lordships.
Council, since you are starting your career.
Yes, your lordships.
And let me tell you, I am not, but courts, tribunals are very, very particular about the attire you wear to court. Very particular.
Pardon, your lordships.
We wear bands, because you can't wear bands, you're supposed to wear a tie.
Pardon, your lordships, but the rule of the competition said that white shirts and blazers are preferable.
Oh, that's all? They didn't specify a tie. Okay, then go ahead. Proceed. Yeah.
Your lordships, the council will be speaking for 15 minutes, in which he'll be dealing with issue 3, which pertains to whether the date of default changes based on the facts, or is it to be taken as the date of NPA. And issue 4, which relates to the admission of application despite an error in the date of default. The council shall seek permission to proceed with issue 3.
Go ahead.
Much obliged, your lordships. Your Lordships, the statutory definition of default under Section 3, subsection 12 of the Code clearly mandates that default occurs when non-payment of the debt or any part or installment has become due and payable and remains unpaid. The legislature chose the term non-payment deliberately, distinguishing it from the NPA declaration, thereby an actual non-compliance rather than a mere administrative class.
Can you read 12 again?
Yes, Your Lordships. Default means non-payment of debt when whole or any part of installment of the amount of the debt has become due and payable and is not paid by the debtor or corporate debtor, as the case may be.
Now please go back.
Yes,
it has where whole or any part of the debt. Correct? One part.
Yes.
Of it. Got it?
Yes,
whole or any part of the debt has become due and payable. Second part. It must become due. It must become payable. Correct?
Yes, Your Lordship.
This is the second. Now go to the third part. And is not paid.
Yes, Your Lordship.
Now connect B and C. It becomes due, payable, not paid. There are three factors.
Yes, Your Lordships.
The third factor makes it a continuous process.
Yes, Your Lordship.
If it's a continuous process, where is a holy date for it?
Your Lordships, the Form 1, Part 4 clearly mandates.
Please, then you should have gone there. You came to 12. I'm asking you 12, you're going somewhere else.
Your Lordships, the third issue.
Okay, let me ask you again, very slowly.
Yes, Your Lordship.
What are you talking about? You're talking about the definition under clause 12, right?
Yes, Your
Are
Lordship.
you wanting me to analyze 12 or do you want me to analyze the form? Which do you want me to do?
Section 3 subsection 12, Your Lordship.
So let's stop there. Let's not jump to the form.
Yes.
Under the clause, can the date change or not?
Pardon, Your Lordship. Can you repeat?
Because under clause 12, it's a continuous process. Continuous process means there is no limitation. It can keep changing from day to day. Every consequent date of default is a date of default.
Your Lordship, the third issue pertains whether the date of default changes based on facts and circumstances, or is it to be taken as NPA in all bank matters. The Council simply humbly pleads that it could not be taken as NPA in all the bank matters, Your Lordship, because there is a distinction between the date of default and the date of NPA. And this distinction has been made by the same Honorable Apex Court in the Lakshmipat Surana versus Union of Bank of India.
Let us see that.
Yes, Your Lordship. The researcher will... Pardon, Lordship. Pardon for inconvenience. The researcher is on to it.
Yes. So what does it say? Where does it say it is a single date?
Your Lordship, the third issue pertains to whether a date of default changes or is it to be taken as NPA in all bank matters, Your Lordships. The date of default changes based on facts and circumstances. Like in the present case, Your Lordships, this is true. And the Council for the respondent
please
does
understand.
agree to
Please,
the
1 minute. One.
Yes, Your Lordships.
In becoming an NPA and date of default, according to you, are two different or are they the same?
Are two totally different concepts.
Very rightly so.
Thank you, Lord.
Because NPA is a concept unique, critical, and important for the purposes of the SURFACE Act. It is not crucial for the purposes of the IBC code. Agreed?
Yes, your lordships.
Therefore, if the date of declaration of NPA is only a technical date, then how is it this can't happen?
Your lordships, can you please reframe the question, your lordship? The council was not able to
proceed in whatever way you want to say.
Your lordship, the bare contention of the council is that the date of default and NPA are two different phenomena. Two totally different phenomena that are two. Yes, it might be possible, your lordship, that the date of NPA can overlap or can ordinarily be construed as the date of default, but it could not be strictly construed as the date of default, your lordships. It keeps on changing with the facts and circumstances of each and every case, your lordships. This is the bare contention of the council, your lordships. And that's why, your lordship, the council believes that when the default is under the OTS, your lordship, this is true. And the council does agree to the contention that the account of the or the loan of the respondents were classified as NPA in 2014, your lordships. But, your lordships, the corporate debtor wanted to resolve that resolve the or pay the loan, your lordship, and this is evident from the multiple OTS that we have sent in those periods, your lordships. But, your lordships, none of the OTS were entertained by the financial creditor. Rather, your lordships, when the COVID-19 struck, and we, your lordship, we as a corporate debtor requested for an OTS, your lordship, then the financial creditor acknowledged that OTS and sanctioned it in our favor, your lordships. And we as a respondent, your lordship, we as a respondent only, your lordship, defaulted under that particular OTS, your lordship, that is strictly under the 10A period, your lordships. This is the primary contention that the council for the respondent wants to place before your lordships.
Continue.
Much obliged, your lordships. Your lordships, in the present case, the financial creditor restructured the debt and sanctioned the one-time settlement on 1/2/2020, expressly extending the time for payment of entire liability to 31/3/2020.
Because of statute.
Pardon, your lordships?
Because of statutory interference.
Your lordship, this is the factual matrix that which talks about when the financial creditor, your lordships, acknowledged and sanctioned the OTS in the favor of corporate debtor, your lordships. By sanctioning the OTS, your lordship, the creditor consciously abandoned the 2014 repayment schedule, and the original loan agreement stands modified, your lordships. And for any default committed there under the OTS agreement, your lordships, has to be looked into and not the original loan agreement, your lordships.
Sorry, I'll tell you why.
Yes, your lordships.
OTS is an arrangement.
Yes, your lordships.
The loan is an agreement.
Yes, your lordships.
The later can't override the former.
Your lordships, the council is not even pleading that it could, the OTS could override the loan agreement. So
your argument that because of OTS the dates change, legally unsustainable.
Your lordship, the council is not arguing that due to the OTS the date changes. What the council is arguing is, your lordship, that due to the OTS that was sanctioned in the COVID-19 period, your lordship, the corporate debtor were unable to pay the payment, your lordship.
Correct. Statutory interference.
Yes, your lordship. The ordinance that was passed by the honorable president, your lordship, that strictly prohibited and put a non-ostenic clause, your lordship, that no insolvency proceedings could be ever filed, your lordships. And moreover, to your lordship, the lordships does agree, the primary contention, that another contention that the council for the respondent wants to plead before your lordship, that as per the mandate of Dena Bank versus Shiv Kumar Reddy, it mentions that the amendment of the pleadings in an application under section 7 could be, your lordships, amended apart from those initially filed along, your lordships. Means that, your lordship, the appellants were at the full liberty, your lordships, to amend the pleadings before when it was put in the NCLT, your lordships. Rather, your lordships, the appellants went on and continued with the same date of default, your lordships, because the appellants
Why are you relying on this judgment? I did not get you.
Your lordships, the reliance on this judgment is particularly because, your lordship, the appellants were at the full liberty, your lordship, to amend the date of default under Form 1 or under Section 7 on Form 1, your lordship, as per the mandate of Dena Bank versus Shiv Kumar Reddy, your lordship. But the appellant, your lordships, move forward with the same date of default, your lordship. They did not change the date of default, your lordships, because, your lordships, they knew that the default was under the OTS, your lordship, that was sanctioned in the favor of the corporate debtor, your lordships. And now, your lordship, when that default came into the period of 10A, that puts a bar on...
Counsel. Question is this. If the question is not what they earlier did was right or wrong. Question is whether the present petition is maintainable in the context of the law. Could they have done it then? Maybe yes, maybe no. I don't know. But that's hypothetical. Question is, does it bar them from doing it now?
Yes, your lordships.
Show me how.
This puts a bar, your lordships,
How?
as your lordships. Even in the case of Ramdas Datta, your lordship, although it is a judgment of NCLAT, your lordships, but your lordships, this shows the procedures that are being followed in the NCLT, and it held that, your lordships, the date of default once mentioned by the appellant in the first round cannot be shifted or changed. Your lordships, the Supreme Court itself has given the full liberty to the, your lordships, to the corporate, to the financial creditor, pardon, your lordships, to amend the date of default, your lordships. Still, under those circumstances, the financial creditor pursued with the same date of default, your lordship.
Counsel, correct me if I'm wrong.
Yes, your
Their
lordship.
cases, not correction. Their
Yes,
cases, we had wrongly mentioned it. This should have been the date, not that. That is why I asked.
Agree, your lordship. The council is not even denying what your lordships are saying. But the mere fact, your lordship, that the date of default cannot be amended, your lordships, just to escape the bar that has been put in the 10A period, your lordship. Yes, your
They
lordship.
are not amending the date. They are saying it was a numerical error.
Your lordships, the word numerical error or clerical error could not be taken as a defense, your lordship, in a case when there is so much of time to amend the pleadings, your lordship. And secondly, your lordship,
there you are right.
The council is not even contending on the fact that what they should do now. Rather, council is explaining to your lordships, or council is pleading before your lordship what they should have done, your lordships. And once the procedures are not followed in a proper manner, your lordships. And secondly, your lordships, in Ramesh Kaimal versus Simons Gamsa, your lordship, it was quite categorically held that the wordings of Section 10A, that no application shall ever be filed, shows the core legislative intent of the Act.
What? Sorry, I lost the chain.
I'll repeat it for you, lordships. I'll repeat it from my lordships. It was quite categorically held that the wordings of Section 10A, that no application shall ever be filed, shows the core legislative intent of the Act, your lordships.
Of that period.
Yes, your lordships.
Correct, that's all.
Your lordships, that's why the council is pleading that the default that has occurred. Your lordship, the account was classified NPA in 2014. But your lordship, the financial creditor kept sleeping on its right, and it did not initiate the insolvency proceedings then, your lordships. Now, your lordships, when your lordship, the COVID period has come, and the financial creditor, your financial corporate debtor, your lordship, has pleaded for another, your lordship, OTS. Then the financial creditor sanctioned the OTS, and your lordship, the corporate debtor was not able to pay the agreed amount, your lordship, due to the COVID-19 pandemic. Hence, your lordships, the Section 10A is prefaced with a non-obstanding clause, your lordship, which overrides Section 7.
Counsel, did your application for OTS happen after COVID or before COVID?
Your lordship, the application of our application of OTS was before COVID, your lordship, or just before COVID, your lordship. But The time period when the debt was to be paid fell squarely within the COVID period, your lordship, which is strictly prohibited by the section 10A, your lordships. If your lordships want, the council might proceed with the timelines of the case, your lordships, if your lordships permit.
Yeah, go ahead.
Thank you, your lordships. Much obliged. Your lordship, the OTS was sanctioned by the financial creditor in the favor of corporate debtor on 1/2/2020. But your lordship, the liability amount was agreed to paid was 31/3/2020, your lordship, and the liability, the period that when the amount was paid fell squarely under the 10A period, your lordships.
So, for the period from 31/3, for the 10A period, no application shall be filed. That's all.
Yes, your lordships.
Correct.
And then your lordship, what the appellant did, your lordship, is that they filed, because the corporate debtor had defaulted under the OTS agreement, your lordships. The corporate debtor, your the OTS that was sanctioned, your lordship, the financial creditor filed an application to the NCLT or the adjudicating authority, your lordship, by mentioning the date of default that fell squarely under the 10A period, your lordships. Because the financial creditor knew that the corporate debtor had committed a default under 10A period, your lordship. Now, your lordships, they vehemently wants to change the date of default and skip your lordship, the bar that has been put on by 10A period, your lordships. That defeats the whole legislative intent and purpose behind bringing this ordinance, your lordships. This is the primary contention, your lordship, that the counsel for the respondent wants to plead before your lordship. Your lordship, the main contention is that why didn't they, if they were under apprehension that there is a clerical mistake or there is a procedural lapse, your lordships, why didn't they amend the pleadings, your lordships? Why did they proceeded with the same date of default?
Go to section 10A once, please.
A minute.
Read the explanation to the provisor.
Just a minute, your lordships. It is to be just explanations, your lordships. If your lordships, just explanations, your lordships, of 10A.
After provided, there's an explanation.
Yes, your lordship. For removal of the doubts, it is hereby clarified that the provisions of this section shall not apply to any defaults committed under the section before 25 March 2020, your lordship. But yes, your lordship, this is the contention that the default was committed under the OTS, which is after 25 March 2020, your lordships. And even the finance creditor themselves have mentioned. Yes, your lordship.
OTS itself means debt a prior to the OTS, isn't it?
Yes.
Yeah.
Your lordships, the inability of the financial creditor to pay the OTS was due to the COVID-19 pandemic, your lordship, and your lordship, the case. Your lordship, in the Ramesh Kaimal versus Simons Gamsa, your lordship, the same apex court has held that the adjudicating authority or NCLAT is not even required to go into the details whether the default is due to your lordship's COVID or not. But if the period is squarely falling under that, the default period is, your lordship, squarely falling under the 10A period, your lordship, the application could not be entertained. Entertaining such application, your lordships, would defy the whole legislative intent of the act, your lordships.
Yes, continue.
Your lordships, para 25 is this. May I read it for your lordships?
Not necessary. Proceed.
Your Lordships, if your Lordships are satisfied, the Council would like to proceed with the issue 4.
I am not giving you any such condition. You may proceed.
Much obliged, your Lordship. The Council for the respondent humbly raises the challenge over the maintainability of the appeal. And the Council for the respondent has several grounds to submit, so your Lordships. First of all, your Lordships, the same question, the same contention, your Lordships, that permitting this application, your Lordship, the Council does agree to the contention that the application is well within the limitation period under as per Article 137 or Section 137 of the Limitation Act, your Lordship. And the OTS and the continuous OTS under Section 18 of the Limitation Act has kept the date alive, your Lordships. The question of limitation is not under play. The Council does agree to this contention of your Lordships. But your Lordships, there are multiple other factors why this application should not be entertained. One of those factors, as earlier mentioned, is your Lordship, that the appellant were under the full liberty to amend the date of default. Still, your Lordship, they proceeded with the same date of default, first of all, your Lordships. Secondly, your Lordship, the date of default is not of a minor technical process or a procedural lapse, your Lordships. Rather, changing the date of default or permitting to change the date of default in this present case, your Lordship, would alter the whole nature of the consequence of the act, your Lordships, and defeat the legislative intent why the Section 10A was brought on, your Lordships. Thirdly, your Lordships, the default that is committed and is under the original loan agreement, your Lordships. Your Lordship, the financial creditor kept sleeping on its right since 2014 when the account was classified as NPA. Neither they went to the DRT, your Lordships, neither they approached the adjudicating authority after the initiation of insolvency and bankruptcy code, your Lordships. They kept on sleeping on their rights, your Lordships. And now, your Lordships, suddenly when the financial creditor has defaulted, your Lordships, under the OTS, they want to, your Lordship, simply claim the money, which is clearly prohibited by Section 10A period, your Lordships, or Section 10A. This is not a mere classification or correction of the date of default in the original petition, your Lordships, but the substantial altercation that changes the very basis of the claim, your Lordships.
Is that the finding of the tribunal?
Your Lordship, this is the contention that the Council wants to put before your Lordships.
Okay.
Your Lordships, all the precedents and the case laws depicts that this application is not to be admitted. Accordingly, your Lordship, the issue 4 must be answered in the favor of the respondents. The operative date of default is 1/5/2020 and not 1/4/2014, and the present application under Section 7 of the Code is non-maintainable and non-tenable, your Lordships. Hence, to conclude the case, your Lordships, the appellant were at the full liberty to amend the date of default before passing of the final order. Secondly, the case is on same facts, same set of timelines. No fresh cause of action has arisen. Hence, res judicata also applies, your Lordships. Hence, to conclude, your Lordships, the simple prayer of the Council is, your Lordships, to hold that the case cannot be admitted, or the petition to hold that the case cannot be admitted due to error in the date of default, your Lordship, despite the date of default.
Okay.
The Council rests its case, your Lordships, and the Council is very obliged and humble to argue before your Lordships.
Thank you.
Thank you, your Lordships.
Manav, do they have a right for rejoinder? I don't think, unless there's something very important, I'm not allowing a rebuttal because I've thrown enough and more questions on them.
We leave it to both of your discretion, sir, for that. As per our rules, we have clearly said that only the appellant will have a right to reply.
Yeah,
The
but
respondent would, but yes, but it is to the discretion of the judges. There's no
Manav, the
mandate.
reason why I'm saying that is, even issues that were not raised by the respondent were thrown at the appellant. So why a rebuttal again?
Okay, sir. Okay, that's
But
perfect, sir.
that is subject to your.
No, we can skip rebuttal and sir rebuttal. I agree with you, sir.
Okay. Thank you then. Students, all of you,